Hi, I'm Erica Cicero from e.cicerolaw LLC, here with your estate planning made easy moment of the week. This week I want to explore the rarely discussed and often overlooked topic of pet trusts. But what is a pet trust? This is a testamentary instrument that provides for the care and maintenance of your pet after your death. Let's go to the Louisiana Civil Code to explore this topic a little bit more. According to Title IX of the Louisiana Civil Code, entitled Trust for the Care of an Animal, a trust may be created to provide for the care of one or more animals that are in being and ascertainable on the date of the creation of the trust. So, in layman's terms, you cannot create a pet trust for an animal you might adopt in the future. This animal must be in your possession at the time the trust is formed. You will need to modify your trust if you adopt a new pet or the existing pet dies. Let's continue with the code. The trust instrument must designate a caregiver for each animal. An animal's caregiver will have the custody of the animal and be responsible for its care. If no caregiver is designated, or if designated or appointed caregiver is unable or unwilling to serve, the trustee shall appoint or act as caregiver. Okay, so this is rather clear, isn't it? You must name the person you want to take care of your animal. If the person is unable or unwilling to take your animal upon your death, then you should have a backup person in the trustee. Or you could name a backup person. To continue, the trust instrument may designate a person to enforce the provisions of the trust if no person is designated, or if the designated person is unable or unwilling to serve. The settlor or any of his successors or a caregiver may enforce the trust. This basically means you need a third party to make sure that your caregiver is actually looking after the animal and is not mistreating the animal and takes possession of the animal to begin with. This is always a good idea from a rational standpoint so that the third party can make sure that the caregiver is not abusing the animal for financial compensation. Also, in the case of the first caregiver being unable or unwilling to take the pet, it's good to have a third party who's responsible for that pet, who could be the backup person, who could take care of your animal, and make sure that everyone involved is fit and willing to take the animal, and that this helpless being is properly taken care of, as you would want. The trust may designate reasonable compensation and expenses for the animal's care. If the court determines that the value of the trust substantially exceeds the amount required to care for each animal, and for reasonable compensation and expenses of the trustee and the caregiver, the court may terminate the trust at the excess portion. This one can be a doozy for some people. You see, there are cases where people have tried to leave astronomical amounts of money to their animal in a pet trust. Millions of dollars seems a bit much to care for a dog's health and maintenance. I know I have a tendency to go overboard at the vet with dental cleanings, yearly blood work, the best food possible, but the court is unlikely to accept money that is simply too much to care for an animal. How much can cats really need to sustain them financially for the future? However, this amount of money that is too much has not been firmly established through legislation. So, depending on the animal, say a racehorse, for example, it would be unrealistic to leave millions. It wouldn't be unrealistic to leave millions for a racehorse because there's trainers and breeders, and just the care of a racehorse is significantly more expensive compared to a dog or a cat. However, the average pet trust with a dog or cat is unlikely to pass muster with the court for that high of a value. But if you have a more exotic animal, an unusual animal like a racehorse or something of that nature, you could leave more money and it could be justifiable. The trust shall terminate upon the death of the last surviving animal. The trust instrument may designate a person to receive the property upon partial or complete termination of the trust. Okay, so finally, once the last living pet passes away, then the remaining funds must be designated to go to someone, because that's the end of the trust. There are everyday examples of when a pet trust is necessary or important. Myself, for example, I have cats, and they bring my husband and I great joy. As mentioned before, I want to make sure that they receive the best medical care possible. So it wouldn't be unrealistic for me to have a pet trust, which I do. This instrument provides financially for the designated caregiver along with certain requirements for the cat's care. I want to make sure that they are medically, nutritionally, and emotionally cared for upon our untimely deaths. This care requirement means that they will live in the same manner that we would provide. It's not unreasonable. We love our pets. Most pet owners would agree that caring for them and making sure they are looked after is reasonable and the responsibility of the pet owner, right? But let's turn to an example that I have come across in practice that's a bit dramatic. We'll call the client Lori. Lori has 2 adult children, Mark and Mary Catherine. She also has a dog named Bodie. She loves Bodie, and he has become her constant companion as she works from home. She brings him everywhere with her, and he brings her great joy. Lori is worth about $10 million and wants to make sure that Bodie is taken care of upon her death. Yes, Lori loves her children dearly, but they can care for themselves. Bodie needs her for everything. He would literally starve without her. So Lori has a decision to make. Who will be the caregiver of Bodie? Since Bodie doesn't really like Mark and prefers Mary Catherine, Lori decides to make Mary Catherine Bodie's caregiver in her pet trust. Although Lori loves Mark, she trusts Bodie's judgment of his character. If Bodie barks at someone, Lori can't trust them with her money. So he's out of the will, or as some attorneys would do in a testamentary instrument, she leaves him only her love. Lori establishes a pet trust where she creates Mary Catherine as the caregiver of Bodie. Mary Catherine has a long list of requirements she must meet to continue as Bodie's caregiver. She must walk him 4 times a day, take him to the groomer monthly, take him to the vet, and do all suggested treatments twice yearly. She must feed him top-grade dog foods. She cannot inherit unless Bodie dies a natural death. Lori can't bear the idea of Bodie being put to sleep. He wants to make sure that he passes away naturally. This is not a provision to protect Bodie's well-being, in case Mary Catherine wants to put him down immediately to inherit money. It's very important to do that and make sure that the animal's not put down if there's a clause that the person inherits upon the animal's death. You want to make sure that the animal dies naturally then, so that the person you leave the animal to doesn't just put the pet down. So Bodie doesn't like Mark. Lori decides she'll leave all her money to Mary Catherine after Bodie's death, since Bodie likes Mary Catherine. She must then deserve the money. Lori establishes her trust so that Mary Catherine gets a small stipend every month that she cares for Bodie during his lifetime, in order to pay for his expenses and upkeep. Upon Bodie's natural death, Mary Catherine inherits what's left of the $10 million that was not used for Bodie's care, which would be a substantial amount of money. Lori made sure to make her friend Robin the backup caregiver if Mary Catherine predeceases Lori or is unwilling to care for Bodie. If this is the case, Robin, her backup caregiver, will step into Mary Catherine's shoes and inherit $10 million, or what's left of the $10 million, upon Bodie's natural death. Although most pet trusts, you do not need to leave the caregiver the entirety of your estate. In some cases, people will do this. Lori could just as easily establish the same pet trust and have divided the $10 million equally between her children, aside from a set amount of money that she would have designated for Bodie's care. If you're interested in creating an estate plan so that you can make sure that your pets are looked after upon your death, please contact my office and we can discuss how we can protect your animals. If you haven't done so already, please like and subscribe for more videos like this.